The courtroom was packed that Tuesday morning, and I could feel Karen Whitfield's smug satisfaction radiating from across the aisle. She sat there in her power suit, lips pursed in that familiar self-righteous way, whispering to her lawyer like she'd already won. The HOA president was about to teach the stubborn ranch owner a lesson. At least that's what she thought until Judge Morrison called the case to order and asked if I had legal representation. I stood slowly, adjusting my tie with practiced ease. "Your Honor, I'll be representing myself." Karen's lawyer, a young man named Bradley Cooper, actually smirked at that. Poor kid had no idea what was coming. "Very well," the judge said. "Please state your qualifications for the record." I cleared my throat. Thomas Mitchell, retired attorney, 35 years with Mitchell & Associates, specialized in property law and civil litigation. Member of the state bar since 1987. The smirk vanished from Cooper's face. Karen's mouth fell open slightly before she caught herself. Life on Cedar Ridge Ranch was supposed to be peaceful after decades in courtrooms. My 100-acre ranch had never belonged to any HOA, separated by miles from Willowbrook Estates. But after Karen Whitfield became president, she arrived one morning demanding community trail access through my land. I refused politely, but her smile hardened. She believed her HOA authority outweighed private ownership. Soon came letters on official letterhead, fake code complaints, and even organized community walks at my property line. When I found her cutting my lock at 2 a.m. to install trail markers, I installed cameras and hired welders for a steel gate. My attorney sent her a cease and desist. Days later, she sued me for obstructing community resources and demanded $50,000 in damages. Her lawsuit was filled with false claims of easements and public access rights. That's when I decided to represent myself. I filed countersuits for trespass, harassment, and defamation. When we met in court that morning, Karen arrived with board members, a newsletter writer, and the belief she'd win. Judge Morrison, whom I'd known from years in practice, presided. Karen's attorney painted me as an unfriendly recluse blocking innocent families. I presented property deeds dating to 1952, affidavits from previous owners, and surveillance stills showing Karen cutting locks and trespassing multiple times. I also produced her 17 harassing letters, 9 false county complaints, and a recording of her saying, "I don't care if he owns it. I'll make his life hell until he gives in." The courtroom fell silent. Karen shouted that it was taken out of context, but her lawyer's confidence evaporated. Judge Morrison calmly asked if they had any proof of an easement. They didn't. She then reviewed my evidence and granted summary judgment in my favor. All Karen's claims were dismissed with prejudice, and my countersuit upheld. She was ordered to pay $15,000 in damages, $5,000 in legal fees, and to stay 500 feet away from my property. Then the judge added that she'd forward the case to the district attorney for possible criminal trespass and recommend the HOA board review its leadership. Karen's face crumbled. 3 days later, I received notice that Karen had been unanimously removed as president and permanently banned from holding any HOA position. She later pled guilty to misdemeanor trespass, earning a year of probation and 500 hours of community service, none related to HOAs. The best part came 6 months after that. The state law school invited me to be the keynote speaker for their continuing education series on property law and civil litigation. My topic: when Karens attack, a case study in homeowner association overreach. I used our case as the centerpiece, complete with security footage and court transcripts. The video went viral on legal education websites. Karen's legacy wasn't the connected trail system she'd envisioned, but as a cautionary tale taught to law students about the dangers of exceeding authority and underestimating opponents. I heard through the legal grapevine that she'd moved to another state. Her Willowbrook Estates house sold at a significant loss, and the new HOA board sent me a formal apology letter along with a fruit basket. As for the $20,000 in damages and fees, Karen's check cleared, and I donated every penny to a legal aid society that helps people fight HOA abuse. They named their new conference room the Whitfield Warning Room. The irony wasn't lost on anyone. Last I heard, Karen was working as a receptionist at a real estate office 3 states away. Her dreams of HOA power crushed under the weight of a restraining order, criminal record, and legal fees that nearly bankrupted.